A recent unanimous Supreme Court decision has generated a lot of discussion about police use of force, traffic stops, and firearms. Some commentators are actually saying that the Supreme Court changed everything. Others say nothing changed. So the court didn't create a new rule. It reminded lower courts to apply a rule that's been around for decades: the totality of the circumstances. And that's a lesson that applies not only to police officers, but also to concealed carriers and anyone who may one day need to defend themselves. I'm going to talk about this important point about motor vehicle stops and use of force, defensive shooting, so stick around. First, let's talk about Barnes versus Felix. So this happened in 2016, folks. This was a Texas traffic stop. The vehicle was linked to unpaid toll violations. So the officer approached, and as he started to interact with the driver, he believed he smelled marijuana. He instructed the driver to exit the vehicle, but instead of complying, the driver decided he would drive away. Police officer ends up on the car, holding onto the car, trying to stop the driver. When he realized that his life was in danger, he fired 2 shots. The driver later dies. The driver's mother filed a federal civil rights lawsuit alleging excessive force. Now, this is an important point. This was not a criminal prosecution. This was a civil lawsuit alleging a violation of the Fourth Amendment. What happens next is the lower courts initially dismiss the case. District Court provides a summary judgment for the officer saying that he was in danger at that moment, holding onto the car, and the case was dismissed. There was an appeal to the Fifth Circuit. The Fifth Circuit affirmed the lower court's decision. Why did they affirm it? Because they use what's called the moment of threat doctrine. Now, this doctrine historically has been applied to civil rights lawsuits to evaluate police use of force, limiting the court's review to the exact second an officer perceived a threat while completely ignoring their actions leading up to that moment. Court focused primarily on those final seconds before the shots were fired. So they basically said at that moment, they said the officer was on a moving vehicle, holding on. He faced apparent danger. Therefore, the force was deemed reasonable. So they affirmed the lower court's decision. Now, we need to mention Graham versus Connor. This is the real foundation, folks, for use of force with police. So this was a 1989 case. Graham established an objective reasonableness standard. So the question is, in certain cases of excessive force allegations, they ask, were the officer's actions objectively reasonable? So the reasonable officer standard, that force must be judged from the perspective of a reasonable officer at the scene rather than with 20/20 hindsight. So they basically ask the question, is it reasonable to say that another officer in the same or similar circumstance would do what that officer did? So it's a facts and circumstances analysis. Subjective intent does not matter. So if the officer had good intentions, it doesn't matter. Whatever their feelings were, doesn't matter. What matters is the facts and the circumstances surrounding the incident and what happened. The core mandate of Graham is really evaluating the totality of the circumstances. So keep in mind that Graham already required the courts to evaluate the totality of the circumstances. So what happened in Barnes versus Felix, the Supreme Court unanimously rejected the Fifth Circuit's narrow approach. They said that courts cannot put on what they call chronological blinders. They must examine what happened before the force and what happened during the force. They must examine the entire sequence of events. So Barnes didn't replace Graham. Barnes reminded the courts to follow Graham. Here's what a lot of the commentators are missing, or at least not talking about. When the Supreme Court said no and kicked it back to the Fifth Circuit and said you must consider all the events leading up to the use of force and the use of force itself, the Fifth Circuit considered all those events, and the result, the officer still won. Barnes really just changed the analysis. It did not automatically change the outcome. So essentially, Barnes won the legal principle. Felix, the police officer, ultimately won the case. So here's why it matters during traffic stops if you carry concealed. So here's an example from my trooper days on car stops. I'm going to give you 2 scenarios of a car stop and what, from my experience, the mentality would be of the officer. So scenario A, you have a cooperative driver. So they pull over immediately. They keep their hands visible. If it's at night, they turn on the interior light for you. They have a calm demeanor. They advise the trooper of, hey, I have a carry permit, or I'm legally carrying, I have a permit. They advise the officer where the firearm is located. I'm carrying the appendix position or the 3 o'clock position. They tell them where the documents are. Hey, my license and registration or my registration insurance are in the glove box. Do you mind if I grab it? They follow instructions. Then in this scenario, imagine for a second they suddenly would reach towards their waistband. Right? So obviously, if it were me, I wouldn't be thinking anything was wrong up until that point where they reach for their waistband. So my perspective as a trooper would be, all right, this is going as well as can be expected. They're following commands. They're not giving me any reason to be suspicious or nervous about what they're doing or what they're going to do next. But of course, that moment where they go for their waistband would be concerning to me. But I would think, okay, the driver's being cooperative. The driver discloses a firearm. The driver appears law-abiding. The driver has followed every instruction. Now let's do scenario B, what I like to call the escalating driver. So this driver delays stopping. They don't pull over right away. Their hands are disappearing or not visible, even when I say, show me your hands. They reach repeatedly around their vehicle. They argue with the officer. They ignore commands. They don't disclose that they're carrying a firearm. And then suddenly, they reach towards their waistband. So do you see the same movement at the end? Completely different circumstances. So the mentality of the officer in this second scenario, scenario B, is what is this guy doing? What's going on here? So you can see there's a completely different mindset from the officer's perspective on these two drivers. Same movement at the end, completely different perspectives. Now, will it matter in the end? Maybe, maybe not. So if something happens and you wind up using lethal force, will it matter what happened leading up to that? Possibly could. The point is that the Supreme Court said to the Fifth Circuit, you need to consider all these things that led up to it. Now, for my New Jersey concealed carriers, I need to remind everybody that current New Jersey law, and the current law I'm talking about, is still under litigation. Some parts of it have been struck down. Other parts are still under litigation. However, currently, the part about mandatory disclosure, if you're issued a permit in New Jersey under the statute and you're stopped or detained by law enforcement, you must disclose immediately that you're carrying a firearm, or if you have one stored in your vehicle. So this is something that you have to do. We could talk about the constitutionality of the law in another video, but currently that is the law in New Jersey. So I just wanted to give you my perspective on carrying concealed, getting stopped by the police in New Jersey. Now, since Bruin, it was June of 2022, so it's 4 years ago, New Jersey has seen a dramatic increase in lawful concealed carry. Prior to that, there were not many, right? So if I as a trooper stopped you and you were carrying a gun, it was either because you were law enforcement, off duty or on duty, or you were armed security going to or from work. Very few people other than those two groups were legally carrying firearms. Otherwise, you were carrying illegally. My point is that since Bruin, it's only been 4 years, the police in New Jersey do not have decades of experience of stopping and interacting with law-abiding citizens who are carrying concealed. This is a relatively new thing in New Jersey. So keep in mind that when people go through this process of getting a background check, the training, the paying the fees, getting fingerprinted, doing all this stuff to carry a gun to defend yourself and the people you care about. So these are the people, in my opinion, that are not coming in contact with police very often. So again, when the police do encounter law-abiding people carrying concealed, in New Jersey at least, there probably hasn't been a lot of interaction since Bruin. So here are 5 tips for a safe traffic stop if you carry concealed in New Jersey. Tip number 1, keep your hands visible. Tip number 2, if you're carrying, disclose it calmly. Probably don't want to use the word I'm carrying a gun. You don't want to say that word gun. Just say I'm carrying concealed, or I'm a lawful concealed carrier and I am carrying. Tip number 3, narrate your movements. My documents are in the glove box. I'm just going to reach for them. Tip number 4, move slowly. Tip number 5, don't argue roadside. So this is important. Even if you think that things are not going the way they should be, you do not start an argument on the side of the road. That is not the place to do it. You can always file a complaint or talk to a supervisor later if you think that things did not go the way they should have gone. But on the side of the road is not the place to do it. The whole goal, folks, is to end the interaction, right, with both you and the officer leaving or departing safely. Here's the bigger lesson for concealed carriers when we're talking about Barnes. I think it's a little bit bigger than traffic stops here. The totality of the circumstances also matters in civilian self-defense cases. So we talked about police. Graham versus Connor is really about police and use of force. The totality of circumstances also matters in civilian self-defense cases. So some questions that investigators may ask if you're involved in a shooting. Were you the aggressor? Did you escalate? Did you follow someone? Did you continue the confrontation? Did you attempt to de-escalate? Did you create distance? Did you issue verbal commands? Were less lethal options available? What do witnesses say, and what do surveillance cameras show? Also, I have to mention your digital footprint matters. So after a defensive shooting, investigators may also review your social media posts, any comments on videos or videos that you actually posted, any text messages, prior statements. So as an extreme example, you post something like, I wish somebody would try me, after like a news article about a concealed carry shooting someone, or I've been waiting for this, or I can't wait to use my carry permit. Obviously, they're extreme examples, but I'm trying to make a point here. They can go back years looking at your social media. Even if you've deleted posts or comments, they're still maintained by the social media platforms for a certain period of time. Now, contrast that with years of showing, either through social media or other means, that you're responsible, that you prefer to avoid confrontation or de-escalate, that you promote safety. Very different pictures, right? So the prosecutor may not just examine what happened that day, they may examine who you've been for years. To sum it up, folks, Barnes versus Felix did not revolutionize police use of force. Graham versus Connor remains the foundation. Remember, that's a 1989 case. What Barnes did was remind the courts that context matters. So whether we're talking about police use of force, a traffic stop involving a permit holder, or a civilian self-defense incident, courts don't simply examine the final second, they examine the entire story, the totality of the circumstances. And that's why what happens before the critical moment may be just as important as the critical moment itself. If you found this helpful, please let me know in the comments. Also hit that like button and share it with anyone you think will benefit. And if you haven't subscribed, consider subscribing. Hit that notification bell so you know when we release new videos. Thanks for watching. Take care and stay safe.